I think we're now ready to continue, Mr. Galbraith-Martin.
The claimants think I've just come on. I'd like to turn to the question of whether the Employment Tribunal is entitled to conclude that the claimants are workers for the purposes of relevant statutory provisions. The real issue in this case has always been in our submission, who do Uber drivers perform their work for? The Employment Tribunal found that they work for Uber. And in our submission, that was a finding that it was open to it to make on the evidence before it. The critical findings of fact are set out in paragraph 77 of our written case, page 159 if you want to look at it. But it's important to bear in mind that in making those findings, the Employment Tribunal necessarily also found that the terms on which Uber rely do not reflect the reality of the relationship. This is something that Lord Justice Underhill in his dissenting judgment really doesn't engage with at all. I want to focus on two matters in particular, which we say are critical, actually, to an employment relationship. That is the question of control and the alleged freedom to decline or cancel trips. So looking first at the question of control, it's been identified as one of the defining features of an employment relationship since the seminal judgment of Mr. Justice McKenna in the ready mixed concrete case some 50, 60 years ago. It's a case that's cited in nearly every employment status case, and unsurprisingly, it's cited by Lord Clark in AutoCleanse. If I can ask you to look at the citation of it in AutoCleanse, please, at 751. Paragraph 18 from the judgment of Lord Clark. A contract of service exists if the following three conditions are fulfilled. The servant agrees that in consideration of a wage or other remuneration, he will provide his own work and skill in the performance of some service for his master. He agrees expressly or impliedly that in the performance of that service, he will be subject to the other's control in a sufficient degree to make that other master, and the other provisions of the contract are consistent with its being a contract of service. Freedom to do a job by one's own hands or by another's is inconsistent with the contract of service. A limited or occasional power of delegation may not be. So he there focuses as a certain criterion on the issue of control. Now, yesterday, Ms. Rose said, well, control is only really relevant to the third criterion of the worker relationship, the question of whether the putative employee deals with the putative employer in a relationship of client and or customer. But we can see here that that must be wrong, because Mr. Justice McKenna is considering the concept of control when asking whether a contract of service exists. That's a Lim A contract of service. He wasn't concerned at all with the Lim B worker definition, and therefore wasn't concerned at all with the client-customer exemption. He's rightly pointing out that control is a feature of a contract of service. It is equally, therefore, a feature of a worker contract, but not specifically or only in relation to the client or customer exemption. It's identified, I accept, by Mr. Justice McKenna here as a second criterion, after that the servant agrees in consideration of a wage or other remuneration to provide his own work. But of course, it logically follows one can only exercise control over someone that is in a relationship with. So it naturally presupposes that the servant is providing his own work or skill in the performance or service of some service for his master. It's in those circumstances that you then go on to ask whether he does so expressly or impliedly, subject to the other's control. So by default, it's a useful indicator of whether the individual is working for the other party to the contract, or, for our purposes, who's working for whom. Contrary to the express terms on which Uber relies, finding of fact made by the tribunal was that it does exercise a significant degree of control over its drivers. And note, Ms. Rose several times yesterday referred to the non-exercise of a contractual power. The non-exercise of a contractual power doesn't mean you don't have that power. Well, except that's right. But this is a rather different situation. We're not here talking about the non-exercise of a contractual power. We're talking about exercising a power over drivers that the written terms expressly state Uber does not have. So if we look first at the terms, page 545. And at paragraph 2.2 in the new terms, reading about 5 lines up from the bottom, as between Uber and customer, customer acknowledges and agrees that customer and its drivers are solely responsible for determining the most effective, efficient, and safe manner to perform each instance of transportation services. Over the page, clause 2.4. 3 lines down, Uber and its affiliates in the territory do not and shall not be deemed to direct or control customer or its drivers generally or in their performance under this agreement specifically, including in connection with the operation of customers' business, the provision of transportation services, the acts or omissions of drivers, or the operation and maintenance of vehicles. And at 2.5, 3 lines down, customer acknowledges and agrees that it exercises sole control over the drivers. But contrary to those express written terms, the finding made by the tribunal is that Uber does instruct drivers how to do their work and in numerous ways controls them in the performance of their duties. That's the finding made at paragraph 92.7, page 393. In our submission, the evidence in support of that was overwhelming. It includes the following. At the point of recruitment, drivers are given a welcome packet which incorporates instructions about how the services are to be provided. The tribunal refer to this in paragraph 48 of their reasons, but they do it by reference to a document, and we've got the document in the bundle at page 600. You're looking at it electronically, it's quite easy to rotate the view. It might appear on its side. So what you have there is a page from the welcome packet headed Safety and Quality. So this forms part of the onboarding process, what happens when drivers attend at Uber London. And they're told that they must be polite and professional at all times. They're told that they must avoid inappropriate topics of conversation. They're told not to contact the driver after the trip has ended. They're required to complete what's called a partner driver information test, or a PIP test, that has a pass mark. You'll see that if you just go on another couple of pages at 603. So hopefully at 603 you have the Uber partner driver in-person test, and you'll see that the pass mark is 70%. Third line up in the text next to the picture. To give you an idea of the sort of things this covers, on page 605, what would you do at the start of every trip? Introduce yourself to the rider and help with any luggage. Page 607, what could you try to do if your rider doesn't know his exact address? Ask the rider if they know what area it's in. What would you do if you took a wrong turn? Be honest with the rider. And so it goes on. It's not just control, it's micromanagement. Now, Uber might say this is all just a matter of common sense. Although some of us, I'm sure, have had some experiences of some of the negative things that are being referred to in that documentation, but it's not the point. These are instructions that are given by Uber London to its drivers. And once drivers have passed the recruitment stage, Uber continues to exercise day-to-day control over them. They're issued with standards advice, the document at 673. These are said to be recommendations, but the tribunal pick up what's said at the third paragraph here. There are some recommendations that if followed, if not followed, not missing at the end of the page perhaps, may constitute a breach of your partner terms or license conditions. Then if you go to page 675, recommendations for safe driving. You should always be considerate of other road users and aware of cyclists. It's advisable to drive in a manner that's comfortable for passengers. Drive responsibly, take breaks. Number 3, do not discuss sensitive or personal topics. Again, examples of micromanagement, not just at the point of recruitment, but throughout the relationship. Your Lordships, my lady will be aware, the tribunal has also found that Uber effectively determines the route taken by drivers because it sends them the route on the app and they depart from it at their peril. This finding was also supported by the evidence. If you look at 513, my client, Mr. Farrer, asking at the very top of that page, hopefully you can make it out, to Uber, please explain this adjustment at the top of the page. And then towards the bottom, hi James, thanks for letting us know. I'm sorry to hear your pay was reduced. Hope you're doing okay. I've reviewed the trip and can confirm the fare was adjusted due to the rider's feedback about the inefficient route that resulted into a higher than usual level of pay. We recommend using the in-app navigation. Well, it's a recommendation, but if you don't follow it, we'll reduce your pay. That's without even reference to my client. Whereas you'll recall the express terms say, in theory, drivers have absolute control over determining the most efficient route to be taken. We know that Uber deliberately does not tell drivers, or certainly did not at the material time, the passenger's destination until the passenger has been picked up. And that's to ensure that drivers do not screen trip requests, i.e. they don't say, I don't feel like going to that particular location. And the rationale for this was explained in Uber's response to TfL's consultation, that document we looked at the start of my submissions this morning. But if you go back to it, please, at 521, and it's on the second page. 522, penultimate paragraph beginning there, has long been strong anecdotal evidence of private hire operators and taxi drivers effectively screening booking requests to adhere to their own criteria, distance, area, etc. The fact, this is 3 lines from the bottom, the fact that an Uber driver only receives the destination for a trip fare when the passenger is in the car is a safeguard that ensures that we can provide a reliable service to everyone at all times, whatever their planned journey. Now, yesterday, Ms. Rose said, well, this is covered by clause 2.2. In fact, clause 2.2 says the exact opposite of that. Clause 2.2 on 545. So clause 2.2, page 545, 5 or 6 lines from the top, beginning halfway along, you'll see where it says driver will obtain the destination from the user, either in person upon pickup or from the driver app if the user elects to enter such destination via Uber's mobile application. If the user elects to enter such information via the mobile application. Now, Ms. Rose also helpfully reminded you yesterday of the finding of fact made by the tribunal at paragraph 15, that passengers usually do notify their destination at the time of booking. That's page 367. So Uber is aware of that information at the time of booking, but it deliberately does not provide that information to the drivers to prevent them screening trips. My own client, Mr. Farrar, gave evidence about this, page 623. There's an extract from his witness statement. So the only information I receive about the customer's request for a journey is the customer's current location and the customer's average rating. Paragraph 60 of his witness statement, I'm not told anything else about the trip request. In particular, I am not told the customer's requested destination. So we know for its own commercial reasons, Uber does not provide that information to the drivers, but that we say is wholly inconsistent with an agency relationship in which drivers allegedly have complete control over their own businesses. It's actually a freestanding inconsistency, although I've dealt with it under the heading of control. We know that Uber monitors its drivers' performance. It can require them to undertake additional quality training. That's the rating-based quality process that begins at 652. Ms. Rose said yesterday, the ratings, that's all just about access to the app. That's not true either. It's part and parcel of a performance management process operated by Uber London. Addendum, that's the document that begins at 542. I'm sorry, 562. And again, it largely replicates the provisions that are contained in the main agreement. I've lost the precise point. I'll come back to that, but it's in that document. I'll come back to that page number. We also have the evidence from the lead claimants. So my client, Mr. Farrer, page 624. So paragraph 62 here refers to the 80%. Drivers are required to accept at least 80% of all trip requests. He then goes on to say that that was applied in practice. Paragraph 63, in an email to one of the other claimants in this claim, Uber advised him, we recommend partners to receive at least 85 to 100% of the trip requests, as to not get your acceptance rate affected. We don't have this particular email in the bundle, the one that's being referred to, but we do have another at 571. This is a Twitter feed in which Uber Support responds to comments made by its passengers on Twitter. And you'll see two passengers are complaining about the fact that drivers are screening fares. At the top, hey Uber, your drivers at London Heathrow London are screening fares, asking where I'm going and then cancelling trips. I have this too, and I want to go for E1 to E3. They don't want a short trip. Now, in theory, under the express written terms, drivers should be free to make those sort of decisions. But the response from Uber Support was definitely not okay. Drivers are not free to refuse trips that they don't want to take, for example, because they're only short. Lord, we therefore invite you to find that contrary to the express written terms in clause 2.4 of the new terms, drivers do not have an absolute or unfettered right to decline trip requests, and the Employment Tribunal was entitled to and correct to find that drivers are contractually required to accept, at the very least, a reasonable number of trip requests whilst logged on to the Uber app. My Lord, as I mentioned in opening, we say there are other features of the relationship that are inconsistent with agency, and other features of the relationship which are inconsistent with the express terms. We deal with that in our written case, paragraphs 114 to 117. I'm not going to take you to them, but Mr. Siegel is going to develop the point about other features that are inconsistent with agency. So in our submission, therefore, there are two findings made by the tribunal about control, about the obligation to work, which, taken together with the uncontested facts, drivers are required to perform their work personally. Uber is not a client or customer of any business carried on by its drivers. those facts together satisfy the statutory criteria, and the claimants are therefore workers, and the tribunal was right to reach that conclusion. As I noted in opening, there can be no substitute for applying the words of the statute to the facts of the individual case, as Lady Hale said in the Bates van Winklehoff case. But that's not an approach, as my lords already indicated in discussions we've had about tax cases, that's not an approach that's peculiar to the field of employment. And as Lord Clark noted in AutoCleanse, citing a number of landlord and tenant cases, it is of general application. I want to take you to just two because I think they make the point really rather nicely. So Street and Mountford, first of all, and this judgment of Lord Templeman in that case, 1887. These were landlord and tenant cases. The facts don't particularly matter, but at letter F on 1887, Lord Templeman has this to say: if the agreement satisfied all the requirements of a tenancy, then the agreement produced a tenancy, and the parties cannot alter the effect of the agreement by insisting that they only created a license. The manufacture of a 5-pronged implement for manual digging results in a fork, even if the manufacturer, unfamiliar with the English language, insists that he intended to make and has made a spade. And then the AG Securities and Vaughan case, 1253, please. This is Lord Oliver. Since lettings of residential property of an appropriate rateable value attract the consequences of controlled rent and security of tenure provided by the Rent Acts, it's perhaps not altogether surprising that those who derive their income from residential property are constantly seeking to attain the not always reconcilable objectives on the one hand of keeping their property gainfully occupied, and on the other of framing their contractual arrangements with the occupants in such a way so as to avoid, if they can, the application of the Acts. And you can substitute in there running a transportation business as Uber does and control over its drivers. Since it's only a letting which attracts the operation of the Acts, such endeavours normally take the form of entering into contractual arrangements designed on their face to ensure that no estate is created in the occupant for the time being, and that his occupation of the land derives merely from a personal and revocable permission granted by way of licence. The critical question, however, in every case is not simply how the arrangement is presented to the outside world in the relevant documentation, but what is the true nature of the arrangement. The decision of this House in Street and Mountford established quite clearly that if the true legal effect of the arrangement entered into is that the occupier of residential property has exclusive possession in an ascertainable period, a tenancy is created, whatever label the parties may have chosen to attach to it. And finally, at 1245, just picking up on a point my Lord Legate made yesterday about contracting out. Lord Templeman relied on that in the context of landlord and tenant cases. You'll see at 1245, beginning at letter E, since parties to an agreement cannot contract out of the Rent Acts, a document which expresses the intention, genuine or bogus, of both parties or one party to create a license will nevertheless create a tenancy if the rights and obligations enjoyed and imposed satisfy the legal requirements of a tenancy. And we say the same applies here. If the rights and obligations enjoyed, as found by the tribunal, satisfy the legal requirements of worker status, they are workers. My lords, my lady, we say something very similar emerges from the tax cases that my Lord Reid referred to yesterday. Mr. Siegel is going to say a little bit more about them, but for my purposes, I rely on what Lord Nichols had to say in the Barclays Mercantile case. And you have that at 789. Beginning at paragraph 28, so 789 at the foot of that page. As Lord Steyn explained in the McGuickian case, the modern approach to statutory construction is to have regard to the purpose of a particular provision and interpret its language so far as possible in a way which best gives effect to that purpose. And then reading on at paragraph 32, 790, the essence of the new approach was to give the statutory provision a purposive construction in order to determine the nature of the transaction to which it was intended to apply, and then to decide whether the actual transaction answered to the statutory description. might be more convenient to analyse the facts and then ask whether they satisfy the requirements of the statute. However one approaches the matter, the question is always whether the relevant provision of the statute on its true construction applies to the facts as found. Lords, my lady, we endorse that. And summarised by my Lord Reid in the UBS case that you drew my attention to yesterday, and I'll gratefully rely on what my Lord had to say there. The facts must be analysed in the light of the statutory provision being applied. That was at paragraph 68. It's page 77 in that additional bundle of documents that was sent to you. My Lord, we therefore invite you to find that the Employment Tribunal was right to conclude that the claims meet the statutory definition of a worker and to dismiss the appeal in relation to finding 1. I just want to say a little, as I've got a couple of minutes left before I hand over to Mr. Siegel, a little about the regulatory regimes. I think it's important to note that the Tribunal didn't place any great reliance on the regulatory regime. It's referred to only very briefly in the Tribunal's reasons at paragraphs 58 to 60. It's no part of the Tribunal's reasoning that the relationship existed because of the regulatory regime. In our submission, requirements imposed or arising from the regulatory regime plainly can also exist as contractual obligations as between Uber and its drivers. And we say that much is clear from the fact that access to the app is personal to a particular driver and is non-transferable. Drivers are not allowed to share their driver IDs. And this was correctly identified by the Tribunal, paragraph 39 of its reasons, as imposing an obligation of personal performance. So there's a contractual obligation of personal performance, even in the documents relied upon by Uber. And of course, the regulatory regime provides a like effect that a trip request accepted by an operator has to be carried out by a particular named driver, i.e. you can't substitute under the regulatory regime. It's common ground that the practical effect of Regulation 11F is to much the same effect as the contractual provision contained in the terms. So we say that's an example of a matter arising by virtue of the regulatory regime that's found its way into a contractual obligation as between Uber London or as between Uber and drivers. And if it's right, one can have a contractual obligation of personal service, notwithstanding the fact that it's also something required of the regulatory regime, well, then one can have other provisions that are incorporated into a contract between Uber drivers and Uber London, notwithstanding the fact that they're also required by way of the regulatory regime. And my lords, I won't repeat the points I made earlier in my submissions about the fact that there must be some sort of relationship between Uber London and its drivers. Otherwise, how does Uber London fulfill its statutory obligations under the regulatory regime? My lords, those are the submissions that I wanted to make in relation to the first round of appeal. As I mentioned yesterday, Mr. Siegel is going to cover, if he feels there's time, what counts as working time. Unless you have any other questions, I'll hand over to him.
I think not. So thank you very much, Mr. Galbraith-Martin. Yes, Mr. Siegel.
Good afternoon, everyone. I invite the court to begin by imagining the following scenario. Uber London has just won its Transport for London licence. The document is at 485. Uber London, not Uber BV, is now entitled, at the top of the page, to operate private hire vehicles in London and to, a little further down, accept bookings for those private hire vehicles. It needs a workforce of drivers to enable it to do so, which it recruits following interview. Successful applicants are asked to enter into standard form contracts with Uber London, which include the following dozen or so terms. Drivers must provide vehicles of a particular sort. When logged on, they should take on driving jobs which Uber London has accepted from its customers, whatever the destination, which they will only be informed of once they pick the customer up. Once a job is accepted, the driver should not cancel. If the driver does not accept trips when logged on, or if he cancels once he has accepted, then Uber London may penalise him by logging him off for a period, in effect reducing the wages he can earn. And ultimately, Uber London can terminate the contract. The driver must not provide his full name or contact details to the passenger, nor ask for the passenger's full name or contact details. Nor will Uber London provide the passenger's details to the driver, even if the passenger has caused damage to the driver or his vehicle. The driver must use the route Uber London instructs at the risk of a deduction from wages otherwise. For completed trips, Uber London will pay a commission of 80% of the fare, which Uber London will calculate according to a formula only known to Uber. Payment will be made for completed trips, even where the passenger does not pay Uber. However, if the passenger cancels after the driver has accepted a trip, the driver has no recourse against the passenger. Drivers are subject to a disciplinary process, breach of which will lead to remedial action or termination, and offences include poor English, poor driving, and inappropriate conversation with passengers. Likewise, remedial action, potentially leading to termination, will be taken against any driver who receives insufficiently good passenger ratings. Uber London will maintain all relevant records, and Uber London will determine passenger complaints, generally without reference to the driver, and may make deductions from drivers' wages in its absolute discretion. Lady, my lords, these terms are not randomly selected, of course. As the court now knows, they are the sum of all the main obligations in this case, either as agreed between the parties or as found by the tribunal. Secondly, to adopt Lord Templeman's metaphor from Street and Mountford, they are the hallmarks of a limb-B worker relationship, whereby an individual undertakes to perform personally any work or services for another party. The hallmarks of what Mr. Justice Elias, as he then was, approved by this court in the Clyde & Co case, referred to as a dependent work relationship. My lady, my lords, any employment lawyer, any employment tribunal would immediately recognise, as this tribunal did, that a contract with these obligations is a worker contract. Now, if you'll bear with me, imagine that 2 years go by and it becomes apparent to Uber London that it can save millions of pounds a year in holiday pay alone if it can remove its drivers from the scope of worker statutory protections. The CEO of Uber London confers with a team of lawyers and asks them to explore what can be done, but with the caveat that all of the above features of the relationship must remain in place. A week later, the lawyers return and inform the CEO that they have devised a workaround. They will restructure the contractual relationship as one of agency, whereby the driver contracts directly each time with the passenger. They assure the CEO that none of the prior obligations has changed, and they run through some of the new terms. Uber London will no longer be a party to the contract, which will instead be with Uber BV. Uber will be recharacterised as not providing transportation services. Drivers will be called customers and will be assumed to be limited companies employing drivers. The commission of 80% paid to the driver will be renamed a commission of 20% paid to Uber. The obligations to accept and not to cancel trips and the disciplinary process will be removed from the contract and the relevant obligations placed instead within a confirmation and cancellation rate process and a driver offence process, respectively. Finally, terms are to be added stating that Uber exercises no control over the drivers in the performance of their work, and that drivers are absolutely free to decline trips or cancel trips. The CEO is very concerned at this last suggestion, which contradicts the requirements he stipulated for the drivers to be subject to Uber London's control, in particular regarding accepting trips and cancelling trips. The lawyers assure him those obligations will remain in practice through the confirmation cancellation rate process, and at worst, the courts will ignore the no control terms in the event of a dispute. CEO has further questions. First, how can there be contracts between drivers and passengers if neither has any practical ability to enforce against the other? It is essential, the CEO says, that this not be permitted. Indeed, the driver must have no means of discovering the passenger's name or contact detail. The parties not being able to enforce legal rights against each other is a problem with the agency characterisation the lawyers concede, but the precise model they have adopted has not yet been tested in the court. And then the CEO is concerned that whatever the written agreements say, the idea of the driver contracting directly with the passenger will not go down well with the public, or the regulator perhaps, who has been making life difficult for Uber London, requiring it to be in real control of who becomes its drivers and how they perform. Will it be okay, he asks, for Uber to continue talking in public and to the regulator about Uber recruiting drivers who work for Uber London, whom Uber London controls, Uber London guaranteeing a reliable service, Uber paying its drivers? Will it be okay for Uber to continue reminding its drivers that they work for Uber? Of course, all of this, as the court knows, happened in the material period, as the tribunal found. The lawyers point out it's most unlikely that anyone, particularly the drivers or passengers, will read the written agreements. They will just tick a box to accept while downloading the app. Anyway, what Uber might say and do once the written agreements have been made may not be admissible as evidence, they suggest. Finally, Uber has tried putting similar written agreements in place in other countries, but the courts have seen through them. The CEO does not want a repeat of what has happened in France, Spain, Australia, or Florida. The lawyers reassure him that in England, the courts should stick to the written agreement. There are risks, the lawyers conclude, but after all, there's not much to lose, and Uber London decides to press ahead and gets its drivers to agree to the new written agreement in the form it is before this court when they next switch on the app. My lady and my lords, this case concerns whether the law is such that those whose work displays these hallmarks of a LIM-B dependent work relationship can be deprived of the few basic and important rights Parliament has granted them by reason of such drafting. The first submission we want to make as to that is that as a matter of applying the correct jurisprudential approach, the answer to that question is no, even before autoclaims and certainly after it. Like Professors Alan Bogg and Michael Ford QC in their article at 2272, we suggest that it is instructive in this context to consider cases from other fields of law, as to some extent my learned friend Mr. Galbraith Martin has already done. I ask you first to look at Bankway at 760. A clause providing that an initial rent of £4,680 a year would be increased on review to £25,000 was included in a tenancy agreement in order to allow the landlord to gain possession when it wanted. Because despite being an assured tenancy with security of tenure, the landlord would be able lawfully to obtain possession if, as was inevitable, the tenants fell into arrears in respect of the much higher rent. At page 764 at H, the findings of the judge are recorded at paragraph 11. Towards the bottom of that page, the judge had found as a fact that this perfectly clear agreement had been deliberately designed to have the potential for allowing the landlord to acquire possession. Over the page, he characterised, he characterised the term in the second line as a device, noting that there was nothing devious or dishonest or concealed about it. At the end of that paragraph, he concluded it was a permissible device. The relevant clause in that case had, unlike in this, been drawn specifically to the tenant's attention and was therefore certainly incorporated in the agreement they signed with the landlord. That's recorded at page 770 at paragraph 41. Moreover, the landlord intended to and did rely on that term in practice. In her judgment, my Lady Arden noted the key submissions of the respondent landlord, which echo many submissions this court heard yesterday. At page 769, paragraph 32, at C, the agreement as to rent was genuine and one which the parties were free to contract for. The £25,000 figure was within the limit provided for in the Act. At paragraph 35, at H, the landlord intended clause 8b3 to be legally binding, and accordingly the concept of pretence had no application. Over the page at 37, there was nothing in the Act to restrict the rent which the parties could agree. Moreover, the tenants were free to enter into the lease and were free on giving 14 days' notice to leave the premises. And at 39, summing up the position as the landlord saw it, the landlord had found a way through the 1988 Act. It was a matter for Parliament to alter the law if it wished to prevent what such landlords do. My lady recorded at paragraph 45 at the bottom of 771 that the landlord invoked the doctrine of freedom of contract, but noted that it is well established that legislation has interfered with that doctrine in the field of landlord and tenant. And my lady agreed at paragraph 49 on the next page, sorry, I beg your pardon, on page 773, that the judicial role is not one of social engineering, but held that it is, of course, the role of the court to give effect to the intention of Parliament as expressed in the words that it has used. And adopting that role, the issue in the case therefore became, at paragraph 51 on the same page, whether the agreed contractual term was, in substance or reality, a provision for the fixing of rent, or a provision to enable the landlord to recover possession, otherwise than in accordance with the mandatory scheme. If the latter, at H, the provision amounts to a contracting out of the statutory scheme. Now, my lady, my lords, with appropriate modifications, the claimants submit that one good way of characterising the issue in this case is to ask, are the clauses in the written documentation providing for an agency relationship, in substance or reality, provisions enabling Uber to act as the driver's agent so as to alter the claimant's legal relationships with Uber's passengers and requiring Uber to act as the claimant's fiduciary in that context? Or rather, provisions to enable Uber London to engage the claimants to perform work or services for it, otherwise than in accordance with the statutory scheme protecting such workers. And in answering that question, one notes importantly at paragraph 52 over the page, my lady's observation that the question whether the document is a sham or a pretence or in substance an unlawful contracting out or evasion of an act of Parliament is a pure question of fact. And as to that, my lady held that the judge had fallen into error by confining himself to the written agreement and failing to consider the surrounding circumstances, including subsequent conduct. And my lady's analysis of the material clause and the surrounding evidence at paragraphs 55 to 56 could be, we say, should be applied mutatis mutandis in this case. May I read from 55 towards the bottom of page 774? When the facts of this case are examined as a whole, it is clear that, as the judge found, Clause 8b3 was merely a device. It was in reality a provision which would enable the landlord to obtain possession of the premises. As such, Clause 8b3 masqueraded as a provision for an increase of rent. It was not in substance a provision for the payment of rent. It was introduced to enable the landlord to bring the assured tenancy to an end when it chose. And over the page, the last 2.5 lines of that paragraph, the landlord may, as Miss Padley submitted, have intended to demand rent, but it had no genuine expectation that it would ever receive any rent under Clause 8b3. This case is a fortiori. Here, there is no evidence that either party intended to rely on the agency provisions, let alone has relied on them, other than as a defence to claims under the relevant statutory protection. Rather, as we shall see, it is clear that those provisions were intended not to be relied on. We take issue with Uber's submission yesterday that the Banquet case is not relevant in the present context. As you know, my lady's judgment was approved by this court in Autocleanse at page 752. At paragraph 23, towards the very bottom of that page, Lord Clerk says, I would accept the submission made on behalf of the claimants that although the Snook case is authority for the proposition that if two parties misrepresent their true contract to a third party, the court is free to disregard the false arrangement. It is not authority of opposition that this form of misrepresentation is the only circumstance in which the court may disregard a written term which is not part of the true agreement. That can be seen in the landlord and tenant cases, and the Banquet case, and my lady's judgment in that case is cited at the end of that list of citation. And the effect of that law is summarised in appropriately broad terms by Lord Clerk at the start of the next paragraph, in similar language to that used by my lady in Banquet. Those cases were, he says, examples of the courts concluding that relevant contractual provisions interposed relevant, genuine, drawn to the attention of the parties and relied on contractual provisions were not effective to avoid a particular statutory result. The next case I would invite the court to consider is one of the tax cases, the case which it is probably fair to say moved the law on most authoritatively in this context. Ramsey and Inland Revenue is at 1001. And it concerned tax avoidance schemes which, on their face, negated the effect of a chargeable gain for capital gains tax purposes. The Revenue invited the House of Lords to treat those schemes as being in reality a nullity, an approach that was described at page 1024 at B by counsel for W.T. Ramsey as revolutionary. Lord Wilberforce addressed that submission, first restating familiar principles, of which for present purposes number 3, just below E, is pertinent. It is for the fact-finding commissions to find whether a document or a transaction is genuine or a sham. In this context, to say that a document or transaction is a sham means that while professing to be one thing, it is in fact something different. And he concluded at page 1027 at B, the approach for which the Crown contends does not introduce a new principle. It would be to apply to new and sophisticated legal devices the undoubted power and duty of the court to determine their nature in law and to relate them to existing legislation. While the techniques of tax avoidance progress and are technically improved, the courts are not obliged to stand still. The claimants would say the same regarding worker rights avoidance. Having noted at D that capital gains tax was created to operate in the real world, not that of make-believe, Lord Wilberforce, referring to two United States cases, set out what he describes just above G as a process of thought which seemed to me not inappropriate for the courts in this country to follow. He cites Netsch, in which the Supreme Court had found a transaction to be a sham because it did not appreciably affect the taxpayer's beneficial interest. There was nothing of substance to be realised by him from this transaction beyond a tax deduction. And Gilbert, in which Judge Learned Hand had noted that if the taxpayer enters into a transaction that does not appreciably affect his beneficial interest, except to reduce his tax, the law will disregard it. And at that same page 5b, Lord Wilberforce records that he was confirmed by such jurisprudence in his belief that, in his words, it would be an excess of judicial abstinence to withdraw from the field in such cases. He applied that process of thought to the schemes under scrutiny and concluded that in neither case was anything of commercial substance achieved by the complex and ingenious schemes. Their sole object and their sole practical effect was to avoid tax otherwise payable. As Lord Fraser put it rather bluntly at page 1038 at F, that tax loss, and it was a tax loss, was not a real loss. Now other lordships agree. Those principles were approved and clarified in the Barclays, Mercantile and Mawson case, to which my learned friend took the court earlier. Can I just return to that, starting at page 790, with a paragraph to which my learned friend has already taken the court, paragraph 32. As you've seen, the essence of the new approach is to give the statutory provisions a purposive construction to determine the nature of the transaction to which it is intended to apply, and then decide whether the actual transaction answers to the statutory description. And again, as you've seen towards the bottom of the page, the question is always whether the relevant provision of the statute, upon its true construction, applies to the facts as found. That is developed, and at paragraph 34, 791, just below C, having referred to Lord Wilberforce's reference to the real world, a good deal of intellectual effort is devoted to structuring transactions in a form which will have the same or nearly the same economic effect as a taxable transaction, but which it is hoped will fall outside the terms of the taxing statute. It is characteristic of these composite transactions that they will include elements which have been inserted without any business or commercial purpose, that are intended to have the effect of removing the transaction from the scope of the charge. That was considered, no doubt rightly, to present problems for tax laws. And at 792, within paragraph 36, towards the top of the page, the House of Lords cites with approval the statement of Permanent Judge Ribeiro in the Hong Kong Arrowtown Assets case. Equally applicable, we say, in this case. The ultimate question is whether the relevant statutory provision, construed purposively, were intended to apply to the transaction viewed realistically. As my Lord Reid alluded to, those same principles were examined and amplified by this court in the UBS case, which the court now has, and to which will also be referred. Can I just take the court to a couple of other paragraphs in that case? I don't have the electronic bundle numbering, but I believe, doing some maths, that 75 is where I want to begin. In any event, paragraph 62.
Yes, that's the right page.
I'm grateful, my lord. My lord, with whom the rest of the court agrees, talks of the significance of the Ramsey case, and in the third sentence notes that secondly, and equally significantly, that case established that the analysis of the facts depended on that purposive construction of the statute. And moving down, that needs to focus on just at D, the commercial reality, and just below D, the transaction as a whole. And then at paragraph 67, my lord picked up that reference to the word reality. That's at page 77, right at the top, and said this: references to reality should not be misunderstood. In the first place, the approach described in Berkeley's Mercantile and the earlier cases has nothing to do with the concept of a sham as explained in the SIR. On the contrary, as Lord Stane observed in the Buchan case, tax avoidance is the spur to executing genuine documents and entering into genuine arrangements. And that leads, my lord, to go on in paragraph 68, as the court has already had its attention drawn, to make the point in the second sentence, that the point is that the facts must be analysed in the light of the statutory provision being applied. That is to say, what facts are relevant depends on whether they are material to the application of the statute. And in this case, the relevant fact is whether the overall outcome of the features of the relationship between the parties is whether the claimants undertook to provide work or services to Uber London. A final point that emerges from the tax cases, but it's been adopted in the employment cases, I don't believe to be controversial in this case. We included in the bundle that was sent this morning the case of Furness and Dawson, and again hoping the arithmetic is correct, at page 55, the last page of that case. Lord Brightman, just above C, says this: for my part, I have no doubt that the correct approach in this type of case, where inferences have to be drawn, is for the commissioners, that's to say the fact-finding tribunal, to determine or infer from their findings of primary fact the further fact whether there was a single composite transaction, in the sense in which I've used that expression, and whether that transaction contained steps which were inserted without any commercial or business purpose apart from a tax advantage. And for the appellate court to interfere with that inference of fact only in a case where it is insupportable on the basis of the primary facts found. And as I say, that has been adopted ever since in the field of employment law. And just to take you to one example, at page 1779, in the Court of Appeal case of Nethermere, you see at C, this means, as explained by Lord Brightman and Furness, not merely that the primary facts as found by the fact-finding tribunal must stand, but also the inferences of fact drawn by that tribunal from the primary facts can only be interfered with by an appellate court if they are insupportable on the basis of the primary facts so found. And of course, in this case, the inference of fact as to whether the claimants were personally working for Uber is just such an inference of fact. Those same principles were applied with perhaps added force by this court in auto claims, in the concept of the Linnaeus definition, namely someone who works under a contract of employment. At page 756, as you've seen at least once, Lord Clark, relying on the critical difference between a case in which employment rights are claimed and an ordinary commercial dispute, namely that organisations offering work tend to dictate the written terms that the other party has to accept. We do not understand the supposed possible inconsistency that Uber suggested might be there between paragraphs 34 and 35 on page 757. The last sentence of the quote of Lord Justice Aitkins within paragraph 34 reads, "In practice in this area of the law, it may be more common for a court or tribunal to have to investigate allegations that the written contract does not represent the actual terms agreed, and the court or tribunal must be realistic and worldly wise when it does so." That, we say, leads naturally to 35, as indeed the first word of 35 would indicate. So, and Lord Clark sets out at paragraph 35 that two things follow from that. First, as you've seen, that the relative bargaining power of the parties must be taken into account in deciding whether the terms of any written agreement represent what was truly agreed. And as to that, as was noted by the EAT, if you will go for a moment to page 350, at paragraph 98, recognition of the imbalance of power between the parties in the employment context has informed the introduction of the statutory rights, such as minimum wage and working time protections, that the claimants seek to exercise in this case. See, for example, my Lord's observation in the Unison case that you were taken to yesterday, but I won't read out, but which follows. Going back to auto claims, to page 756. The second thing that follows, as noted within paragraph 35, is that the true agreement may have to be gleaned from all the circumstances of the case of which the written agreement is only a part. As has been said, this is an important point. As in the landlord and tenant cases like Bankway, and contrary to Uber's case, in making its assessment, the tribunal is required to look at all relevant evidence. And that evidence includes at least the following: the terms of the written agreement as a whole, not just the ones on which the employer relies. The circumstances in which the agreement was entered into, if that is the right way to characterise a tip while signing on to a pact. And the reality of the arrangement between the parties is evidenced in Australia by their subsequent conduct. Any or all of those factors may demonstrate the artificiality of the terms on which the employer does rely. If, on the other hand, as Uber proposes, you take the written documents as the starting point and ask only whether their terms are fictitious or a sham, you may well, as Lord Reid suggested yesterday, not get to the right answer. That is the correct legal approach to this case, and it is the one that the tribunal adopted. And before the short adjournment, can I just make two short but important points about the ambit of that evidence, that relevant evidence in this case? First, as regards the terms of the written agreement as a whole, Uber is wrong to say, and it has said so repeatedly, including yesterday, that the tribunal disregarded the entire written agreements as fictitious. On the contrary, the tribunal supported its conclusion that the claimants were Limb B workers by reference in part to several of those written terms. What the tribunal did find, and the relevant part of their reasons is at page 393, at the end of paragraph 91, was that the characterization of Uber acting as agent for the claimants who were making contracts directly with passengers was a pure fiction which bears no relation to the real dealings and relationships between the parties. And what might be described as Uber's sleight of hand in this regard is insidious, because Uber moves from the false premise that the tribunal dismissed the whole agreement as a fiction, then to attack many of the features of the relationship between the parties which the tribunal found constituted features of a Limb B worker relationship as being consistent with the written agreements, which of course they are. That is simply to knock down an aunt Sally. Secondly, and relatedly, the reality of the arrangements between the parties does include the requirements of the regulatory scheme. And we go a little further, I think, than Mr. Galbraith Martin did by reference to Gillam at page 1490. We say that Uber makes a bad point by reference to paragraph 18. This is the case about the district judge. At 18, Lady Hale is not saying that one must ignore the requirements of the statute in determining the actual obligations of the parties between themselves. On the contrary, between H and J, as she points out, was the situation in that case. It may be that most or all of the essential components of the relationship are derived from statute. And we have never really understood Uber's point on this. If the regulatory regime requires Uber London to impose certain obligations on its drivers, then those obligations are imposed by Uber London on its drivers and are nonetheless obligations by reason of the fact that Uber London had no choice but to impose them because of the regulatory regime. My Lord, if that's a convenient moment, I may propose to stop there.
Yes, thank you very much, Mr. Siegel.
Could I just ask a quick question?
Of course, my lady.
If it's permitted by the President before we rise, just swiftly, in case you want to think about it, would it be a better explanation of auto claims to acknowledge the role being played by the statutory regime? I think we could think, perfectly happy to reply.
I'm the only reason I pause is that my lady is obviously making a comparison between that approach and another approach, which I take my lady to have inferred was the approach I was advocating, but I'm not sure that I would assent to the proposition that the approach I was advocating was particularly different from the approach my lady's just said might be better. So I suppose my proper answer is that is the proper approach, and if I have indicated that the approach was something less than that, then may accordingly.
Very well. We'll adjourn now and sit again at 2 o'clock.